Hello and welcome. My name is Alan, and today we will be doing the next episode on our series of the Supreme Court. Today we talk about the J Court, the first Supreme Court of the United States. Of course, we talked about last episode about the Supreme Court coming to being with the Constitution and the Judicial Act, um, which helped create the Supreme Court. And of course, the first Supreme Court was under first U.S. President George Washington. When he first picked the court, there were only 6 members, with the Chief Justice being one John Jay, who was from New York. The first 5 members all got voted in on the same day. And then the 6th member came in about 6 months later or so. 5 months later. But, yeah. The first 6 members of the court is John Jay, John Rutledge. John Jay was of New York. John Rutledge of South Carolina. William Cushing of Massachusetts. James Wilson of Pennsylvania. John Blair of Virginia. And James Iredell of North Carolina. Iredell being the 6th justice who came in 5 months after the first 5. But the Chief Justice of that court was one John Jay. He served from October the 19th of 1789 to June the 29th of 1795, at which point he did resign, which was a total of 5 years, 253 days. Now, let's talk a little bit about the cases the J Court saw. Let's see. The J Court itself, that first court, was seated at the old City Hall in Philadelphia, Pennsylvania. And, you know, as of yet, they had no official Supreme Court. But some of the primary cases that came about under the J Court was Van Staphorst versus Maryland, which is considered the first docketed case of the Supreme Court settled before arguments, and it was in 1791. Although the court agreed to hear and decide the case, the suit was settled before oral arguments. So, yeah. They also was over the case West versus Barnes, which was in 1791. which was considered the first decision of the Supreme Court strictly interpreting procedural filing requirements mandated by statute. Let's see. Next was Georgia versus Brailsford, which was during 1792, and it said that a state may sue in the Supreme Court to enjoin payment of a judgment on foreign debt until it can be ascertained to whom the money belongs. In this case, the state was suing in the Supreme Court to enjoin payment of a judgment in behalf of a British creditor taking on debt, which was then confiscated by the state. So, yeah. They also were over Raeburn's case, which took place in 1792, which decided justicability and separation of powers. And in it, the Supreme Court was invited to rule on whether certain non-judicial duties could be assigned by Congress to the federal circuit courts in their official capacity. And then we had a continuation of the Georgia versus Brailsford case from 1792, this one in 1793. And the court held that upon a motion to dissolve an injunction, the court held that if the state of Georgia had the title in debt, upon which no opinion was then expressed, she had an adequate remedy at law by action upon the bond. But in order that the money might be kept for the party to whom it belonged, ordered the injunction to be continued till the next term, and if Georgia should not then have instituted her action at common law, to be dissolved. So it was a follow-up of the previous case being brought to court and kind of resolving the issue. They also saw Chisholm versus Georgia in 1793, which was the first major case. A federal jurisdiction over suits versus states, and the state's sovereign immunity, and it led to the 11th Amendment, which the 11th Amendment does state, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, or by citizens of subjects of any foreign state. And from what I kind of understand, that just seems to say that it doesn't handle foreign matters. You know, this is solely dealing with the U.S. Let's dig up the link here to look at the case a little more in depth. Is considered the first U.S. Supreme Court case of significance and impact. Given its date, there was little available legal precedence, particularly in U.S. law, and the case was superseded in 1795 by the 11th Amendment, which I just read to you. So yeah, this is the first large case you should know if you want to know anything about the legal history of the U.S. In 1792, in South Carolina, Alexander Chisholm, the executor of the estate of Robert Farquhar, attempted to sue the state of Georgia in the Supreme Court over payments due to him for goods that Farquhar had supplied Georgia during the American Revolutionary War. United States Attorney General Edmund Randolph argued the case for the plaintiff before the court. The defendant, Georgia, refused to appear, claiming that as a sovereign state, it could not be sued without granting its consent to the law or to the suit. So let's take a little further look here. Okay, the decision, in a 4-1 decision, the court ruled in favor of the plaintiff, with Chief Justice John Jay and Associate Justices John Blair, James Wilson, and William Cushing constituting the majority. Only Justice Iredell dissented. At that time, there was no opinion of the court or majority opinion. The justices delivered their opinions seriatim, that is, individually, and in ascending order of seniority. The court ruled that Article 3, Section 2 of the Constitution abrogated the state's sovereign immunity and granted federal courts the affirmative power to hear disputes between private citizens and states. So, in other words, whether Georgia felt it had the right to not show up if it didn't give consent to the suit, the court felt otherwise and felt that the individual had a right to sue the state. Because you got to remember, before this point, the states in the U.S. that formed the U.S. all were under the Articles of Confederation, which was a lot looser and gave the states much more power than the federal government. So they all still wanted this level of sovereign immunity. And thus, they were like, we feel we don't have to deal with this. But the court said, no, you do. Let's see. In his opening words of his opinion, Justice Wilson stated the essential principle on which the case turned. This is a case of uncommon magnitude. One of the parties to it is a state, certainly respectable, claiming to be sovereign. The question to be determined is whether this state, so respectable, and whose claim soars so high, is amenable to the jurisdiction of the Supreme Court of the United States. This question, itself important in itself, will depend on others. More important still, and may perhaps be ultimately resolved into one no less radical than this: do the people of the United States form a nation? In his dissenting opinion, Justice Iredell stated, a general question of great importance here occurs. What controversy of a civil nature can be maintained against a state by an individual? The framers of the Constitution, I presume, must have meant one of two things. Either one, in the conveyance of that part of the judicial power which did not relate to the execution of the other authorities of the general government, which, it must be admitted, are full and discretionary within the restrictions of the Constitution itself, to refer to antecedent laws for the construction of the general words they use, or two, to enable Congress in all such cases to pass all such laws as they might deem necessary and proper to carry the purposes of this Constitution into full effect, either absolutely at their discretion, or at least in cases where prior laws were deficient for such purposes, if any such deficiency existed. So, yeah. Iredell stated that neither of these things was argued in the case, and reasoned that under common law, each state was sovereign, just as under English law, and that they could not be sued without their consent. Although Justice Iredell's was the only dissenting opinion, his opinion ultimately became the law of the land. The states, surprised by the decision of the Supreme Court, called for the 11th Amendment to the Constitution, which precludes a state from being sued in federal court without that state's consent. And the amendment would be ratified by February of 1795. Well, 12 of the 15 states had ratified it by that point. South Carolina ratified it in 1797, and New Jersey and Pennsylvania took no action on ratification. In 1795, the 11th Amendment was ratified to negate the holding in Chisholm versus Georgia. Under the 11th Amendment, citizens of one state or of foreign countries can only sue a state with the state's consent, or if Congress, pursuant to a valid exercise of 14th Amendment remedial powers, abrogates the state's immunity from suit, as was the case in Fitzpatrick versus Bitzer, 1976. So, once again, let's read that 11th Amendment. The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state, or by citizens or subjects of any foreign state. So, in other words, like we just got through reading there, the state can't be sued unless it agrees to it, whether it's by an individual or by a foreign country. Although the case, as we mentioned, Fitzpatrick versus Bitzer in 1976, did state that Congress has the power to abrogate the sovereign immunity granted in the 11th Amendment, meaning that a state can be sued by an individual if Congress grants that capability. But yeah. And let's look at the rest of the cases under the John Jay Court. Once again, we got Georgia versus Brailsford, 1974. So we had 72, 73, 74, Georgia versus Brailsford. And it was the first jury trial in the Supreme Court, and the final conclusion of Georgia versus Brailsford. So that case kept, falling out and coming back, falling out, coming back. Let's see, and essentially it just said that debts sequestered but not declared forfeit by states during the American Revolution could be recovered by bondholders. So, that particular case held a lot of firsts in U.S. legal history. And the final case that major case they proceeded over was the United States versus Todd in 1794. And it was a case regarding invalid pension of a Revolutionary War veteran. The case was initially unpublished, but a note paraphrasing the case was appended to the opinion in the United States versus Ferreira or Ferreira from 1849. And a transcript of the records of the case is published in the Washington and Lee Law Review. But those are the major cases that the John Jay Court saw. Let's look over the rest of the members of the John Jay Court. We did mention Chief Justice John Jay of New York, serving 5 years and 253 days from October the 19th, 1789 to June the 29th, 1795. There was also John Rutledge of South Carolina. He served 1 year, 17 days. And that was from February the 15th of 1790. So even though he was confirmed on September the 26th, 1789, he didn't take effect till February the 15th, 1790, and until March the 4th, 1791. William Cushing of Massachusetts served 20 years, 223 days. So the first really long-serving justice of the Supreme Court. Cushing served from February the 2nd, 1790 until September the 13th, 1810, in which he died while still as a Chief Justice. So, yeah, he served for a long time. Next is James Wilson of Pennsylvania. He served 8 years and 320 days as a justice from October the 5th, 1789 to August the 21st, 1798, in which he also died in office. John Blair of Virginia served 5 years, 265 days from February the 2nd, 1790 until October the 25th, 1795. And the last of those first 6 members to get confirmed in the inaugural court is James Iredell of North Carolina, who served 9 years, 161 days from May the 12th, 1790 until October the 20th, 1799. Now, on the Jay Court, there is also 2 replacements we see. That Washington also added on. Thomas Johnson of Maryland is the shortest term ever for a Supreme Court justice at only 163 days, serving from August the 6th, 1792 to January the 16th, 1793, having resigned. So yeah, Thomas Johnson of Maryland. And then the second one was William Patterson. Well, Thomas Johnson replaced John Rutledge, so that's who he replaced when he came into the Supreme Court. Other than Thomas Johnson, we see William Patterson, who replaced Thomas Johnson. William Patterson was from New Jersey. And he served 13 years, 181 days. From March the 11th, 1793 to September the 8th, 1806. And then, funny enough, we have Rutledge, who had resigned after spending just over a year as a Supreme Court justice, being replaced by Thomas Johnson, who spent 163 days. He resigned. And then Johnson was replaced by William Patterson, who died when he was in office. But at that point, we had Patterson, Iredell, Blair, Wilson, Cushing, Rutledge, and Jay. In 1795, we have John Rutledge come back to the Supreme Court. And this time he would become Chief Justice. But that will be part of our next set of justices we will talk about when we talk about the Rutledge Court and the Ellsworth Court. But I will have the sources listed in the description below. As always, educate thyself, think, read, study, learn. Someone tries to tell you something you have trouble believing, ask them to cite their sources. I'll see you all in the next episode. Until then, later.